Well, hello, my friends. Welcome to me, your host, Christian Watson. My friends, the confusion of terms and language is perhaps the greatest threat to the continued adherence to truth and the foundations of the American Republic that we've faced in a very, very long time. Because the American Republic is fundamentally situated on ideas of truth that are rooted in an objective understanding of reality. However, I don't think there has been a more evident moment of this threat than in the past few days as of the making of this video, which has showcased the response to the Roe v. Wade rulings. Indeed, many people, after the Supreme Court overturned Roe v. Wade in the Dobbs case, have gone to the streets of their state capitals, have gone to the Supreme Court itself, and have shouted the court is illegitimate. And they have said that this is another example of the patriarchy, and they have criticized Justice Thomas's, essentially his blog post opinion about a legal process, getting rid of a legal process of the court, in his opinion, improperly applied in other cases. And they have interpreted that to mean that the United States is going to be a theocracy and that everyone is going to be destroyed and subjugated who is not Christian or whatever. There's been a lot of gloomy narratives coming out of the mouths of everyday people, but there's also been, those narratives have been reinforced and given power by politicians and, at large, the media. And of course, there is one particular instance of this that I want to focus on for this video, and that is the use of the term rights. Now, my friends, the media and politicians, after the Dobbs decision was handed down, began using the word rights in an improper way. Joe Biden said that rights, women's rights, reproductive rights, abortion rights, all those terms have been used interchangeably, are under a threat. And so is the right, in his word, according to his response, so is the right to privacy, liberty, and equality. They're all on the ballot, he said. The New Zealand Prime Minister said that rights are under assault as well, and said that having an abortion is a right. Breyer, Sotomayor, and Kagan, in their dissents, called the Dobbs ruling an assault on women's rights and their status as free and equal citizens. Nancy Pelosi said the goal of the Dobbs ruling was to rip away the right to make reproductive decisions. Eric Holder, the infamous Attorney General who gave weapons to Mexican drug cartels, used the term reproductive rights in his critique of the ruling. AOC also used the term in her critique. Senator Tammy Baldwin used the term in her critique. Joe Manchin, who claims to be pro-life, used the term rights in his critique. Justin Trudeau used the term women's rights in his critique of the ruling. Stacey Abrams used the term rights in her critique. This is getting somewhere, don't worry. Protesters in Boston said, what do we want? Abortion rights. When do we want them? Now. The media is also a culprit in this misuse of the term. SCOTUS blog, which is the premier source on coverage of Supreme Court cases, used the term constitutional right to abortion in their report of the Dobbs case. The New York Times used it as well. CNBC used it as well. Time magazine said that this case foreshadows the dereliction of other rights as well. Reuters used the term as well, saying that other rights may be rolled back. Daily KOS also used the term as well. There are so many people using the term rights to describe having an abortion and to describe what the effect of the Dobbs case was. But of course, they are doing so, my friends, improperly. Now, the rights response to this has been largely, well, there is no constitutional right to an abortion, so you guys are just being crazy. This response is correct. The Constitution does not give a right to an abortion, but as a constitutional conservative, it behooves me to say the following thing. The Constitution gives you no rights. The Constitution gives you nothing. The Constitution merely protects what you already have. To use the term give suggests the Constitution is the reason that you have rights, but this is backward and warped. Because rights are not truly given to you by the Constitution. You already have them by nature of you being human. And this is where the left's misunderstanding of the term rights comes in. And this is where I believe, as someone who studies philosophy and who has a very particular interest in the development of rights theories throughout history, have to come in as well to settle the record. So, my friends, we have to ask ourselves, what exactly are rights? What does it mean to have right. And so to answer this question seriously, we have to consider the origins of words, because right, of course, is a word that has a very particular meaning, but also a very interesting development. So I'm going to use Brian T. Tierney, his book, The Idea of Natural Rights, which if you guys are interested in the idea of rights and where they come from and the development of these theories about history, please pick up Tierney. He is a wonderful, wonderful, wonderful scholar. I think that his work, everyone can benefit from reading his work. It is wonderful. It is well-sourced and everything of that sort. But he traces the origins of the word right back to a Latin phrase, eus, so to speak, that was first used by Francisco Suarez. Now, Francisco Suarez was a Spanish thinker, a Spanish philosopher, who used the term eus in this way. He said in his writings, I quote, "According to the strict signification, eus is called a kind of moral power which anyone has concerning his own property or something due to him. So the owner of a thing is said to have a right in the thing, and a workman is said to have a right to his wages. So eus simply means something that is due to you, something that belongs to you." Now, Grotius, one of my favorite philosophers who came after Suarez and used his work to develop these theories more, Grotius had this idea that eus had three meanings. One of those meanings has to do with justice. Eus was a description of what was just. The second had to do with what kind of reason is right, so how you apply your thinking in the right ways to do it. And the third is what we are interested here in our understanding and exploration of the word right. The third was the following. The third was, according to Grotius, eus is a moral quality of a person enabling one to have or do something justly. Now, as Tierney goes on to explain, this moral quality could also be called a faculty. It could include power over oneself, meaning liberty, and powers or claims in relation to other persons or things. And so this idea of eus would go on to be developed by other philosophers like Hobbes and eventually Locke. And I won't get into the big development of all these words. It's not really important unless you're really engaging in a philosophy of language, or history of the philosophy of language. For our purposes, all we need to know is that eus simply means, or us, I can't pronounce Latin, so it's eus, I believe, simply means the retention or the status of something that already belongs to you. And from that is where the moral idea of rights flows from. There is a through line between Hugo Grotius' ideas of rights, and Grotius was actually, the founders read Grotius, Jefferson read Grotius, and he actually influenced their constitutional theory. And between Locke, who of course the founders read, and there's actually incredible Lockean influence in the Constitution, who said that we all have the right to life, liberty, and property, and it is the institution of government to preserve these things. Now, Grotius and Locke differ in their idea of rights, primarily in where they believe the status of rights is. Locke did not believe that rights are alienable. He believed they are inalienable, meaning they are resolute, they are not taken away. Grotius believed that you could sell your rights, or you could give them away if you wanted to. And they also had different ideas about political mechanism, right? So for Grotius, the idea of justice is keeping people in possession of what we already have, in quiet possession of what is already ours. That would mean keeping us in possession of our rights, which already belong to us. Locke would agree with that, but Grotius did not believe that people had the ability to overthrow a tyrannical government. He did not believe in the right of resistance, so to speak. So there's fine distinctions, but the point is this. Out of this milieu of eus, came what the United States Constitution took as the concept of rights. The idea of natural rights, the idea that rights belong to you and cannot be taken from you unless you are killed. But so long as you are alive, your rights remain resolute no matter what anyone else does. And the source of this is man's right to self-ownership, which is also his right to property. So you own yourself, you have right to self-ownership. But in that, you also are able to own property as well. You're able to preserve your life. You're able to use your liberty, which Grotius says is your power of acting, to go through the world in a manner that is respectful of other people's other people's rights. That is the proper conception of rights. Things belong to the person, not subject to external fiat. Now, the term leftists are using to describe rights is the term positive rights. And this is an idea that someone does not have the right to refrain from violating what you already have. Positive rights signifies two things. Number one, you don't already have something, that you need something that you have to get for somebody else to be able to live a good life. And number two, someone has an obligation to provide you with that something else. So whereas a negative rights viewpoint would say, well, I have a right to my life, so you cannot murder me, a positive rights viewpoint would say, I have a right to my life, so give me health care. But healthcare is a service that springs from someone else's faculty of reason and thus is in the domain of their own liberty, which you, under the negative rights paradigm, must respect. But according to leftist ideology, you don't have to respect that idea because that person has an obligation by virtue of some abstract idea to give you what is already in their possession. This is an inversion of justice, this is a warped understanding of rights, and this is precisely what abortion protesters and opportunists and politicians like Michelle Obama, like Barack Obama are using in their analysis of the Dobbs decision. And as I mentioned, it is a fundamental, flagrant confusion of terms. Rights, as the etymological base, ius, has shown to us, are things that belong to you, not things that are given to you. And the Constitution, sure as hell, doesn't have the power to change human physiology and change the nature of rights. The Constitution merely recognizes what we already have in our possession, as Grotius would say, as he describes justice. Also, there's a further reason why the idea of positive rights makes no sense. If rights, again, are a matter of ius, and they're a matter of things that already belong to you, if that is literally the origin of the word, then you saying that rights are not a matter of that is an attempt to redefine the basis of the word itself. This is not like when words have double meanings, like when you can say, I'm going to kill the lights or I'm going to kill a person. Well, in both cases, you're still doing something that eliminates something. In one case, you're eliminating light. In the other case, you're eliminating a life. It's still, both of those meanings still adhere to the foundational premise of the word kill. But positive rights doesn't even adhere to the foundational premise of the word rights. It completely and utterly guts it and redefines it. Thus, positive rights is not only invalid because it is definitionally unsound, it is invalid because it is an attempt to redefine a word and present itself as that word, when in all reality, it is simply an illusion masquerading under that word. It should be rejected as forcefully as these nonsensical, emotionally laden, progressive outcries over Dobbs should be. Now, what this ruling did do, this ruling was a check on the excesses of judicial activists who fundamentally believe, people like Kagan and Sotomayor, who fundamentally believe that your rights come from fiat, that your rights come from being signed away or signed to you by the good graces of a bureaucrat, and not from within, not from nature. And that was a viewpoint that was strictly repudiated today, or a few days ago when the ruling was made, by a leader that said that the Constitution does not say it, if it does not recognize it, it is not correct. It is not a right, so to speak, and it is not within our jurisdiction to then try to interpret something that is not there. My friends, understanding moral theory, understanding where words come from, understanding the historical debate around terms like ius and rights, that is what helps you get a fuller picture of what's going on. The fuller picture is this, my friends. Rights are natural. They are not circumstantial, they are not conditional. But the left has this idea of conditional rights that they are now using to scare people into believing are under attack. The term rights that they're using is actually a term fueled by emotional affectation. It's a term that is meant to trigger a survival instinct within you, which actually, funnily enough, the survival instinct belongs to the right of self-preservation. So they're using a right against a right, if you think about it. So they're trying to trigger the survival instinct in the minds of the ignoramuses who do not understand what a right truly is, to then have them go out and spread more disinformation and more lies throughout the air about what rights are. But this has got to end. Rights have their epistemological and etymological base in ius, and that's where they must have that base for them to have any coherence. And the Constitution is founded on this deeper understanding of what rights are, on this deeper understanding of truth born through objective reality. And it is therefore incumbent upon the legal system to affirm the roots of these words, to affirm natural rights, not to act against them. But unfortunately, for many years, judges have been acting against the term of natural rights and have been giving people illegitimate, magical rights that don't exist and aren't rights in the first place. And that is what Dobbs was a revolt against, and thank goodness for it. Because if this process continues, the constitutional ethos of our nation will be violated, and the constitutional legitimacy of our document will be violated as well. Because a legal document without moral legitimacy is nothing more than a poor attempt at tyranny. Because without moral legitimacy, anything and everything can be justified. And that is the real story of this Dobbs case. Not rights being violated, but the ethos in which our understanding of rights is contained and enriched being protected. Hallelujah for that. My friends, think on it. I love you guys so much. If you love me, please subscribe to this video. Please share this video. Please like this video. Please be sure to comment on this video. My friends, this message is dynamite. I love you guys so much, and please stay attentive. Bye, guys.